Good afternoon, everybody. I see that everybody's still joining, so we're just going to give a minute or two so that everybody can jump into the webinar. You are welcome to post in the chat box where you are from. We would love to see where you are from and say hi. So please, you're welcome to say hello. Hello, Bloemfontein. Hello, Rolene from Nelspruit. Oh, Jeffreys Bay. Nice at the ocean. Hello, Tuli. Good afternoon, everybody. We've got Pretoria in the house. Grahamstown. Phoenix. Another one from Grahamstown. A lot of people from Gauteng. You are most welcome. Westland. Hello, Pretoria. Welcome. Lovely to have you with us this afternoon. A lot of Bloemfontein, Vrystaat representing well. There's some Struisbaai. Hello, Marina. Welcome to you as well. I'm going to give it a minute or two. There's someone from Gansbaai, also close to the ocean. Welcome. Krugersdorp. Durbanville, and again from KwaZulu-Natal. We are well represented well across the country, and we are so happy to have you here. Roodepoort and Tata. Hello, Babsie. Welcome. Okay, I think there's still a few joining, but I think we are now 2 minutes past 2. So a very warm welcome from my side. My name is Vinette, and I am the National Sales Manager from LexisNexis South Africa. And we want to welcome you to our webinar this afternoon. Thank you for joining us. So I can see there's a lot of representation across South Africa. So whether you are a seasoned property practitioner or just starting out in the rental space, today's webinar is specifically designed to unpack a topic that is critical to your business operations, the FIC compliance, and what every property rental professional should know. So that's why we are so glad that you are here. So as you know, the FIC, the Financial Intelligence Center, plays a vital role in the safeguarding of South Africa's financial system, safeguarding the country against money laundering, terrorist financing, and other financial crimes. So you as property practitioners are classified as an accountable institution. So in this afternoon's webinar, our speaker will touch on what is expected from you as the accountable institution, compliance and compliance to FIC specifically, the POPIA Act and how that ties in, and also how to avoid the common pitfalls that could lead to penalties and reputational risk. So, because being informed isn't just good practice, but it is also good business. So before I'm going to hand you over to our speaker today, he's already in camera. Welcome, Adrian. Before I hand over to you, just a few house rules from my side. You will see that there's a Q&A box and there's also a chat box. So we ask you to please, if there's any questions, we are more than welcome to ask them. We've got a panelist that's in the background that can assist you with your questions. I want you to please post your questions in the Q&A box right at the screen. And if there's anything else, we will then attend to that. So the chat box was just to greet everybody. And I also would like to assure you that this session will be recorded and will be available on the LexisNexis YouTube channel. So you will be able to go back and have a look, at the recording again. So without further ado, we are joined today by Adrian Mains. You can see his face on the screen now. And he is from Masthead, our expert compliance partners. So Adrian is a compliance fundi and is here to explain the do's and the don'ts in navigating key regulations like FASE, FIC, and the POPIA Act. Thank you, Adrian, and enjoy the webinar. Over to you, Adrian. Thank you.
Thank you, Vanette, for the very, very warm welcome. It's an absolute pleasure to be here today with everyone. Thank you for everyone who has joined in from all over the country. Today's session, I promise, will be informative to say the least. As Vanette said, I'm joining from Masthead. I work across various fields of compliance, POPIA, FICA, and then primarily FASE. I'm joined today by a panelist from Masthead as well, Matthew Jonkers. And today, at a high level, we're taking you through the rules of the game you play day to day, the need to knows right now and going forward, the don'ts, obviously, essential practices connected to that, and how LexisNexis could potentially make your life a lot easier with their easy-to-use comprehensive solutions. So without further ado, I'll jump right into it from my side. You'll just give me a moment. I'm bringing up my presentation now. Okay, so there's not much of an overview that I'm going to take you guys through today. Just reiterating what the topic and the focus is of today. It is tenant data and POPIA, amongst other things, including FICA. And the general consensus, as mentioned by Vanette, just what is it? Everybody who rents property, sells property, or participates in facilitating the transaction, what you need to know now and going forward. And as I said, at a high level, we're going to look at the legislation that's applicable, and we're going to start now with FICA. So, as Vanette rightly pointed out, estate agents are accountable institutions under the FIC Act. Specifically, as you can see on screen, under Item 3 of Schedule 1 to the FIC Act. And let's take a second to unpack this. How does it start? If you go to Item 3 of the FIC Act, or Item 3 of Schedule 1 to the FIC Act, sorry, right now, what you're going to see detailed there now is an estate agent as defined in the Estate Agency Affairs Act of 1976. Not very specific, unfortunately. We're actually going to have to go to that piece of legislation to determine who is an estate agent for the purposes of the FIC Act. More to this, though, what you have to understand is what essentially complicates or compounds the issue of gaining the necessary understanding is the fact that the act that I just now mentioned, the Estate Agencies Affairs Act, was repealed in 2019 by the Property Practitioners Act. And the significance of this is that it further conflates or confuses who is an estate agent for the purposes of the FIC Act, who is an accountable institution, because this act has added to the definition of estate agent, essentially. No longer an estate agent, actually, but a property practitioner, as many of you already know. And that definition has been expanded to include certain auctioneers, managing agents, business brokers, trustees, bond or mortgage originators and bond brokers, property developers who market or sell properties, persons who market or sell timeshare or fractional ownership, and homeowners associations. But I need to make it very clear now. If you perform the activities or carry the title of anybody I just mentioned moments ago, that does not conclusively mean now that you are an estate agent for the purposes of the FIC Act. And I'll tell you why in a second. We go to PCC 56, published by the FIC. Now, I just want to take a moment to digress, if you will indulge me, to explain what a PCC is, what it stands for. It's a public compliance communication, and it's authoritative in nature, published by the FIC, and they consider this the only formal recognized guidance, for a lack of a better expression, published by them. It helps you interpret various elements of the FIC Act that you need to incorporate into your specific FICA processes of your organization. And it does a lot of other things beyond that. It helps with interpretation of the Act. Some PCCs are specific, driven towards selected accountable institutions like PCC 56. This is for you, my estate agent friends. It helps clarify this whole issue I'm unpacking now of who is an estate agent for the purposes of the FIC Act. So without further ado, let's read into this a bit more. Estate agents, we must understand to include property practitioners under the new law, i.e. the Property Practitioners Act, but only for those persons who do the same kinds of activities that estate agents used to do under the old law being the Estate Agency Affairs Act. So it's not so much about title. That should be your key takeaway. It's activities based, as are most, let me rather rephrase to say, as is the test to determine whether most accountable institutions are such. It's really based on your activities. Before unpacking the issue of what activities now make you an accountable institution and a state agent under the FIC Act, let's just understand these 2 points below that. So anyone registered as an estate agent prior to February 2022, i.e. the implementation of the new legislation, will remain an accountable institution in terms of the FIC Act. You can consider yourself safely an estate agent, and you would need to comply with the FIC Act. Any person, and I want you to pay careful attention to the wording on the last point of the slide, any person performing the activities of an estate agent, although they may be referred to as a property practitioner after February 2022, you are also an accountable institution. So now we know it's activities based. Let's take a second to unpack those activities. What activities make you an estate agent? So it's anyone, and please take this with a pinch of salt I kid you not, when I tell you the definition, it's quite exhaustive. It goes over 1, 2, 3 pages. For the sake of ease of reference, let me rather say that I've condensed it down here. So please don't take this at face value. An estate agent is anyone who helps people sell, buy, rent, or manage property for payment, whether for your own account or on behalf of someone else. Importantly, this includes employees of estate agencies, company directors, senior management of estate agencies, and even certain employees of law firms. And as I've pointed out in red, if they do estate agent work. And to just unpack that last element a bit more, what do I mean by that? Legal and candidate legal practitioners are not, strictly speaking, estate agents if they do this work as part of their legal practice. What do I mean by that? I elaborate a bit more on the last point on the slide. You need to operate under your own name in the capacity of a law firm, not another company. You are incorporated as a law firm or company. You act in the capacity, strictly speaking, of an attorney, and the fees you receive, although it might be related to a property matter, it's received for legal services rendered, strictly speaking. The moment you veer and operate outside this box I've denoted, you are performing the work of an estate agent for the purposes of the FIC Act, and additional obligations become applicable, such as dual registering as both a legal practitioner or law firm with the FIC, and then in turn also an estate agent as defined. So we understand a bit more now about the activities of what make you an estate agent. What now? Put quite simply, well, the long and the short is you now need to start complying with the FIC Act. And I can promise you, at first impression, for most of you that started dealing with FIC, heard about FIC, and just decided to take a quick Google, what is FIC? What's this about? How does it apply to me? You would have noticed it's a fairly complex piece of legislation. Complying with it could at the outset seem a bit insurmountable, but I'm going to kind of share with you an approach that we employ here at Masted to make it more comprehensive and digestible, more manageable, the task of complying in and of itself. And we refer to this simply as the 7 pillars of FICA compliance. So what it starts with is registration. What do I mean by registration? An accountable institution within 90 days of becoming an accountable institution needs to register itself as such with the FIC. And that includes appointing a FIC compliance officer for your organization. That is non-negotiable. And that person being registered as such with the FIC under your organization. So that's registration in a nutshell. Governance. The FIC is, and I think you will notice this as you start to unpack various FIC-related literature, they are very big on the aspect of accountability. So they have ingrained certain accountability measures, protocols into all accountable institutions vicariously through the legislation by prioritizing this issue of governance. And what does governance include? That includes, as I mentioned earlier, the appointing of a FIC compliance officer. And then also this very important aspect of the most senior management or authority and or board of directors of all accountable institutions ultimately being held responsible for the adequacy of an institution's compliance with the FIC Act. So please be mindful of that when you outsource certain FIC-related matters. Lack of a better expression, I say outsource, but you seek assistance, consultancy, because you're just genuinely looking for help. You need to understand that those people aren't going to be held liable. You cannot turn around at some point in time when you're sitting in front of the FIC and say, ABC and associates, as an example, they assisted us with our RMCP. They're the ones that got it wrong. The FIC does not care. And they've said this publicly. They've come out in FIC tribunal decisions to say it's not a matter of concern. These external parties, it's organization only and the most senior persons within that organization. So please take note of that. Then this is probably your biggest and most onerous requirement, at least that's what I believe. It's the developing, documenting, and implementing and maintaining of an RMCP. What is an RMCP? Some of you may be asking right now. It stands for Risk Management and Compliance Program. Us here at Masted, we like to simply refer to it as the FICA constitution of any organization. What does this mean? This is your overarching governance framework, your compliance framework, your blueprint to comply with FIC at an enterprise level and at an individual level. And this is quite a comprehensive document, and it's also a living document. It's not a document you draft, you put in a shelf, and you let collect dust for the next year or two, or until whatever time you deem is necessary or fit. It's something that it changes your day-to-day operations. It's something that you factor in, and this document tells you exactly how to do that. And if you want a kind of general rule of thumb to test how comprehensive this document needs to be, if someone walks into your business for the first time, an employee specifically, and this person is going to be part of your ongoing FICA operations, this person should be able to, by law, you have to grant this person with access to your RMCP, all employees within the institution, but they should be able to pick up this document and understand exactly how your organization complies with the FIC Act and its various obligations, and what their specific role is as part of the larger functioning FICA infrastructure and processes of your particular organization. That's an RMCP. If you would like to find out more about this, please do come chat to us. We're happy to just share insights and give practical tips away on how to draft one if necessary. Staff training and employee screening, also quite a big one. What this at a high level entails is the FIC Act details that you need to provide staff at least annually with 2 types of FICA training. That is training on the FIC Act and related, at least annually. That means it needs to be accompanied by an assessment as well. You need to be able to evidence that this happens. And then there's also the the issue of training the staff, once again, at least annually on the RMCP itself. Once again, it's implied it should be accompanied with an assessment, and this should all be documented. Then also on this point, employee screening under Directive 8 published by the FIC, all accountable institutions are required to screen all existing and prospective employees using a risk-based approach, and they are supposed to be screened for three things. That is competence, integrity, and then their sanctioned status against the TFS list or the UNC 1267 resolution list. In other words, sanction screening. Then customer due diligence. This is also quite a big one. A lot to unpack there in and of itself. Essentially, there are two forms, according to the FIC Act, of customer due diligence, and that is onboarding, due diligence at onboarding stage, and then ongoing due diligence. And following this, all kinds of other weird and wonderful requirements, including screening and reporting connected to customer due diligence. But again, that's something to be unpacked for another day. Then the issue of reporting. This pretty much would stay the same in all organizations. It'll be dressed differently. And there'll be certain reporting structures from institution to institution at an internal level, but the way it comes to the FIC is ultimately all the same way. And you will learn more about that if you delve into the matter. And then, of course, record keeping, which speaks to every other pillar above this. You need to make sure that your record keeping is meticulous, well maintained, and record keeping of all the above is maintained. And if you unpack this matter in the FIC Act as well, you'll see it deals with issues of how records should be safeguarded. If you deal with third parties for record keeping purposes, do you have SLAs in place? Is that information easily accessible and readily ascertainable? All these things go into that. So those are the 7 pillars of FICA compliance. One thing I just want to bring to the forefront, amongst a lot of other things, but I think this is something very close to the FIC's heart right now, is the RCR submission. What does that mean? What does it stand for? RCR stands for Risk and Compliance Return. It's a submission you make to the FIC to basically give them a gauge of what your existing FICA processes and infrastructure look like right now. What are you really doing? What aren't you doing? And so on and so forth. This obligation to submit this report, it's mandatory for those of you that don't know. And the deadline for this was actually mid-2023, if my memory serves me correctly. So if you haven't done it, please know that the FIC encourages people to still submit following the deadline ending. They need that information. It's going to help them assess our risks as a country at a holistic level and bring it down to a more sectoral or sector-specific level. So please do complete that as soon as possible. If you need help, assistance, guidance on how to go about fulfilling this requirement, call the FIC. Reach out, log a compliance query on their website. Alternatively, come chat to us as well. Okay. The last thing I just want to leave you with on the FIC side of things is the practical resources, and may I importantly add free practical resources that's going to help you now from the outset to start becoming FIC compliant and tackling matters such as drafting an RMCP and so much more. That is PCC 56, which we've already touched on now at the beginning. It's PCC 53, only applicable in certain circumstances. Please read PCC 53 carefully. The National Risk Assessment of June 2024, the Sectoral Risk Assessment for Estate Agents, the Guidance Note 7A, read together with the FIC Act. If you're trying to draft your own RMCP and looking for practical ways of how to go about that, I would say start here. Guidance Note 7A, read together with the FIC Act. And then, of course, PCC 5C. The list really does go on, as I state on the slide. Please do go and check out the FIC's website. Under media, it might be general notifications, it's spread across the board, but they have separate tabs for directives, PCCs, and all things related. Okay, that's FIC in a nutshell. Let's take some time now to unpack POPI or POPI, whichever way you would like to refer to it as. So before we really start unpacking this, let's just take a moment to understand the purpose of POPI. Whose interest does it serve? What does it ultimately aim to do? What does it aim to achieve? Amongst other things, there are 4 primary things that POPI does. That is protect. Protect what? Protect the constitutional right to privacy. That's for organizations and for natural persons. When protecting rights in the Constitution, it's very important that the protection of that right doesn't infringe unnecessarily on any other rights. So what POPI tries to do is balance this interest here, protecting personal information, preserving this constitutional right to privacy, that is balanced against other important constitutional rights, such as the right to access of information and the right to freedom of expression. POPIA then, at a practical level, this is us now, it aims to regulate how personal information is accessed, collected, used, shared, transferred, safeguarded, amongst so many other things. And then lastly, to provide a mechanism to consumers and anyone alike to protect their personal information and ultimately, as I said, give effect to that constitutional right to privacy. So you would recall on the previous slide, I briefly touched on personal information. So POPI stands for the Protection of Personal Information Act, promulgated in 2013. It's a comprehensive data protection law. And what does it seek to ultimately protect and regulate? Personal information. What is personal information? As said on the slide in front of us right now, it is any information relating to an identifiable living natural person or identifiable existing juristic person, i.e. a company or organization. This includes obvious information such as names, contact details, but also information such as gender, marital status, age, language, identifying numbers such as an ID number, email addresses, physical addresses, telephone numbers, social media handles. Now, we understand the purpose of POPI. We understand what personal information is. Let's start delving into the issue of who POPI applies to. So the easiest way to understand the scope of its application and whether or not you fall within its ambit is to understand whether you are a responsible party, or as the Act says, the responsible party. What is the responsible party? So the FIC tells us, not the FIC, apologies, the Act tells us it is a public or private body, personal entity that determines the method, the how, and purpose, the why, for which personal information is used. So with that being said, I think it's clear as day. You listening to me now, you are probably sitting are in possession of personal information. You are the responsible party. So now we know, have a bit of a better idea of when this applies. But to be a bit more specific, each time personal information is used, accountability for compliance with the FIC Act will always rest with the responsible party. This is called the accountability condition, Section 8 of the POPIA Act. The responsible party may be one person or company or several persons or companies working together, processing information, personal information together. So we have a better idea of when POPI applies. When does POPI not apply? Are there instances? Of course, as in most pieces of legislation, there are always exemptions. So our guiding light here is sections 6 to 7 of the Act. That states that POPI will not apply to the processing of personal information in the following circumstances, which I've listed at a high level on the screen. The first one is personal or household activities. So the processing of personal information purely for personal household activities, this is obviously not an exhaustive list. It's quite wide. A lot of things could fall into this category, but general example, a contact list on your personal cell phone. POPI does not apply there. The second instance will be where personal information specifically, has been de-identified. What do I mean by that? So information can still be personal in nature, but if it cannot be connected to an identifiable natural person or juristic person, then POPIA does not apply. So an example of this in practice would be when someone sends out an anonymous survey that is conducted to collect personal information, but it cannot be traced back to the survey participants. POPIA does not apply here. The information has been de-identified. Then, activities by public bodies which relate to national security. So this is where, example, identifying the financing used for terrorist activities, some kind of organ of state that intervenes in with the affairs of some kind of public body. Then the fourth instance is the functions of the judiciary and the Department of Justice in preventing, detecting, investigating, or proving offenses, or prosecuting offenders, or executing criminal sentences. Example would be when a police officer gathers personal information from witnesses or suspects in an ongoing investigation. And the last instance would be when the processing of personal information is for the sole purpose of journalistic, literary, or artistic expression. However, please, let's not get carried away with this one. It's under the condition that in that instance, the freedom of expression weighs more heavily in the public interest than the right to privacy. So an example of that would be when a journalist writes an article speculating about a politician that's involved in some kind of money laundering scandal. That would be a practical example of that last instance. Okay, so we understand the purpose, a bit more about the purpose of POPIA, when it applies, when it does not apply, who it applies to. Now it's the actual practical elements of POPIA. The actual processing, collecting, accessing, storage, use of information. And we're going to systemically unpack that. There's a lot more that goes into this. I want to be very clear. But we are going to start with access, work our way into collection and then use, and then briefly touch on security as well under POPIA. So starting with access. As a general rule, personal information can only be collected from lawful sources, from lack of a better expression. Those lawful sources, the alternatives I've mentioned on screen, but as a general rule, Section 12 of POPIA provides that personal information must be collected directly from the data subject or collected via one of the alternatives listed on screen. Now, I mentioned data subject. Who is a data subject? Quite simply, the person to whom the personal information relates to. So if you do not collect the information directly from the data subject, as in accordance with Section 12, alternative sources will be public records, or where in an instance where the data subject has deliberately made the information, this personal information, public, or in an instance where the information collected from another source, a third party, with whom the data subject had already provided consent. So a quick practical example of what I mean there. I work in the financial services sector. I work with brokers largely. These brokers, they communicate with your product providers, i.e. your Sanlums, your Old Mutuals, your Investex, and so on and so forth. Client, myself, approaches the broker, says, listen, I'm looking for life cover. I conclude a lawful contractual relationship with him to be provided with that product. Now, to successfully fulfill those obligations promised to me in the contract, the broker needs to liaise with the product provider, the Sanlam, the Old Mutual. Sanlam, Old Mutual can lawfully get that information from the broker because they are fulfilling a function regulated under a contractual obligation relationship concluded between me and the broker. So I hope that makes sense. Okay, stolen access. Just like when there are instances where POPIA doesn't apply, there are instances where you do not need to collect the personal information directly from the data subject, aside from what I had previously mentioned. So these are instances where the information, it's just not reasonably practicable in the circumstances to collect that information, but directly from the data subject or from any other lawful source, but those instances are to be judged by the information regulator. Please put that in the back of your mind. Remember that. Then information that is kind of akin to the instances I described where POPIA doesn't apply. Collecting the information is for judicial or Department of Justice functions, such as police investigations. If collecting the information is in aid of tax collection, collecting it for legitimate interests of the responsible party or a third party to whom the personal information is supplied. If collecting the information is in the interest of national security. So that's access in a nutshell. What about collection? Now, on the issue of collection, just understand, I'm going to eventually lead up to this element of consent and how consent works in this context. So just bear in mind, everything now is being sent with the building up to consent, the issue of consent and how it's treated under POPIA. So what we first need to understand about collection and collecting personal information from clients is you need to understand first and define clearly what is the specific lawful purpose that I'm collecting this information for. Now, some of you are thinking, why would I state it to myself? Why would I even need to document it if it's for my own accord? We're going to get to that in a second for whose benefit is this really for. But what you need to understand now is at some point you're going to need to disclose to a certain individual this is, and very clearly, not vaguely, not implied, these are the reasons why we need the personal information. This is who we'll be sharing it with. This is how we're going to process it. That needs to be stated in plain, clear, explicit English. And just on the issue of lawfulness there on screen, it is not enough for you to have a purpose. That purpose needs justification. Specifically, it needs to be lawful, amongst other things. Please remember that as well. So then still on collection, the types of information you collect, I'm more speaking now to the grade of that information. So under section 16 of the Act, it says once you've collected information, the onus is on you to maintain the integrity, the quality, the accuracy, the completeness of that information. Why? Because most data degrades in quality over time, depending on the nature of the data. For example, people change their addresses, their phone numbers, or work emails relatively often, while data such as blood type, they will stay the same for the subject's life, right? So bearing in mind the initial purpose and this general requirement set out in section 16, please ensure that you implement the necessary protocols to maintain, update information, considering the nature of the information. If it's something that's not subject to change, obviously it's going to be less onerous. But if you understand the nature of the data you're collecting and why you're collecting it, please comply with section 16, design protocols around this to ensure that information is accurate, complete, not misleading, and updated. Now, you'll recall I was talking about moments ago the issue of clearly defining, stating the purpose, the lawful purpose, may I add, of why you're collecting this information. Who are you stating that to? Who are you defining that for? Let's go over to section 18 for a second. Section 18 stipulates that data subjects must be informed when their personal information is collected. This we simply refer to as the notification duty. What needs to be disclosed? Aha, it comes back to that slide I was talking on moments ago. The purpose, the intended use of that information. Who will you be sharing it with? How will it be processed? Is it going to be adequately safeguarded? These are all things you need to consider, and a practical way of, without fail, disclosing this to clients, that prospective clients, existing clients, people you engage with. The most practical solution is a privacy statement / policy. So I don't know how many of you have gone to a website and the first thing that pops up is a privacy statement. And I'm not going to be the first or the last one to admit that I kind of just skip over it and just click OK so I can go about doing my business. But now you have a better idea of why those privacy statements are put in place and policies are put in place. It's not just for namesake or for fun. It's because it is a requirement, and you pretty soon need to start doing the same. Wherever in your existing infrastructure processes you are collecting personal information. And amongst others, these are the questions you should ask yourself when drafting your privacy statement or policy. Who is the recipient? What information is being collected? Why is it being collected? What is the purpose? Who are you going to share it with, and why? The last element somewhat the last element of collection that I quickly want to unpack with you guys is timing of notification. We discussed notification now and the need to make notification, but when. This is broadly distinguished into two situations. Information collected directly from data subjects versus indirectly. So remember, we discussed alternative sources and instances where you don't need to collect information directly from a data subject. Put that in the back of your mind for a second. In instances where you do collect directly from the data subject, before that information is collected, you need to notify the client, provide them with this privacy policy statement. And this is important. As I mentioned earlier, we're building up to consent. This is important in the process for you to obtain lawful consent from these people. More to this, now it's the second situation where it's collected indirectly from persons. In these situations, please just know that the general rule of thumb is they want you to collect it before you start processing that information. But if it's collected not directly from the data subject, you are allowed to, as soon as reasonably practicably afterwards, provide the necessary data subject with the notification. Now, finally, consent, as I was discussing with you. The key things that you need to understand around consent is everything discussed up until this point now. For consent to be valid, for you to lawfully start processing personal information that you've collected from your data subject, you need to ensure that the client has been able to make an informed decision. This is the true meaning of consent. They need to understand the nature and the consequences of what will follow. So Section 11 of POPIA provides that personal information may only be processed if the data subject or competent person, in the case of a child, consents to the processing. There are instances where consent does not need to be obtained. It largely relates to the instances where POPIA does not apply, or where we're dealing with organs of states, or if it's for purposes of tax collection, or it's a matter of national security. But please go to Section 11 of the Act if you want to understand in exact detail these particular instances. Two things. Objection. You need to understand that a data subject can object to the processing of their information at any point in time. The moment they object or withdraw their consent, you can no longer process their personal information. But of course, there are conditions attached to this. I would strongly encourage you to go to the Act and read and find the specific details on that. So I'm almost done with the POPIA slide. The POPIA slides here. The last two things I'm going to quickly take you through is use and security. Starting with use of information. On a practical level, what I need you to take away from today's webinar is please record keeping of processing operations. So we understand processing to be the issue of access, collection, the safeguarding of it, amongst other things. Record keeping here is important because the onus to prove to the information regulator that you've complied will always rest with you. So that's why record keeping is extremely pertinent, and perhaps LexisNexis can help you with that as well. Two more things I need you to understand about use of personal information. The Act distinguishes between general personal information, for lack of a better expression, and then also special information and personal information about children. I encourage you, please go to the Act and read on the specifics of this. If I had more time today, I would have loved to unpack it for you guys, but maybe another time. On security. So the Act sets out very stringent conditions around security. Following today, you need to conduct a risk assessment of your existing infrastructure and processes. You need to do risk identification, establish what deficiencies there are in your current security protocols. Once establishing and identifying various risks, you need to attach certain internal controls to that to mitigate those risks from materializing. Then you need to constantly audit and kind of evaluate, reassess. Are those risks still relevant? Have new emerging risks appeared? Do I have the necessary resource to mitigate against it? And that then pours into updating those safeguards. Ladies and gentlemen, that's POPIA in a nutshell. I just want to tie it all together and speak to you about essential practices for estate agents. The three things that we believe are essential practices in today's day and age, this business, is performing credit history checks, checking for red flags in rental history, and employment verification. Why do these things matter? You'll be surprised to know as you start delving into FICA and POPI more, that these things are not just best business practices. These things are actually going to become important components for you to comply with these various pieces of legislation I just described now. And I mean, if I had to unpack it on a best business practice level, how it benefits you purely in a fiscal sense, I mean, if you do credit checks or credit history checks, it reduces financial risk, it predicts future behavior, protects the landlord's income stream, amongst other things, saves time and money. These are the obvious things. Red flags in rental history helps spot problem tenants early, reduces property damage risk, it protects landlord's reputation, amongst other things, and then employment verification, once again, another no-brainer. It ensures tenant has a steady income, it gives insight into stability, and it allows you to actually assess in real time affordability. Now, you see there's a very big question involved there. What about LexisNexis in this conversation? How can they help you? Well, I don't think I can say it better than them. So I'm going to hand over to Vinette, who's appeared now on screen again, and Alan. We're going to take you through how exactly LexisNexis can help you incorporate these things into your existing operations. Thank you, everyone.
Thank you, Adrian. Thank you so much. Excellent. And thank you for breaking it down and making it easy, digestible for us. It's a huge topic. And touching on specifically with the rentals, I've got my colleague, Alan, who is also our sales manager. And I'm going to hand over to him, speaking specifically to how LexisNexis can assist you screening, verifying, getting information of the person that's going to rent from you. There's also now a poll on the question. Please just, if you can click on a yes or a no, if you would like assistance with the POPIA or the FIC compliance. Adrian touched on the RMCP as well as some other documents that we can assist you with. So if you can just click on that, on the poll, please. And then, Alan, I'm handing over to you. Thank you. Alan, I think you're still on mute. Sorry. No, we still can't hear you. Let's see. No, maybe I know sometimes it goes into sleep mode, so maybe you can just keep on talking. Can't hear you, so sorry. No, Alan, we still can't hear you. I think, Alan, in the interim, maybe just for now, maybe just step out for a second and then just rejoin, if that's okay with you. And then we can start Q. I'm going to ask you, one of our marketing, just to put up the other poll. So there's another poll, if you can just complete that while we are looking into Alan rejoining us. And then let's just see if there's, please, like I said, there are a few, if there's any questions that you would like to ask myself, there you'll see the other the poll question. So if you can just complete that, and then one of our LexisNexis consultants will make contact with you. If there's any questions from your side, please post it in the Q&A. We've got Adrian by our side now. So Adrian, there's one question here. If you can please answer that. A general or special power of attorney obtained from a data subject, does this give you sufficient consent for FICA or POPIA? More specifically, will you comply in this instance?
I'm so sorry, Vanette, for this. Would you mind just repeating the question? I'm just
Yes, sure. No problem. A general or a special power attorney from a data subject, does this give you specific consent or sufficient consent for FICA or POPIA? More specifically, will you be compliant if you have a special power of attorney of getting information on behalf of someone else?
Okay. So it's quite a loaded question. What I will say is this, it's a yes and no situation. You would recall in the presentation I said, what is the purpose for which that information, that special information, if you've been granted with this general or special power of attorney, what personal information are you going to be processing? What will you be using it for? That's the only way you can truly answer that question, whether that consent obtained is sufficient. So I know it's not a direct answer to your question. I would love to answer it specifically. If you would like to delve into the matter deeper, please contact me after this. I would love to unpack it for you, but that's the high level answer for now.
Okay.
Vanette, can you hear me now?
Yes, there we can go. Thank you. Adrian, we'll come back to you. Over to you,
No
Alan.
stress.
Thank you.
Thank you so much. Apologies for this, everyone. I'm not sure what happened over there. Okay, Vanette, can you see the screen?
Yes, Alan, thank
Yes,
you.
Alan, we can see it.
Okay, so welcome everybody to our Tenant webinar. I hope you've enjoyed the session thus far. Today we are going to focus on verification solutions, which is available through LexisNexis, specifically Lexis KYC, Lexis RefCheck, and also Lexis Windeed. And I will show you today how these tools will support your compliance, risk mitigation, and effective decision making. Okay. Okay, so if you look at the first slide, this is Lexis KYC. And what this platform does for us is it validates ID numbers and associated data, marital and death status, and also a range of demographic and compliance data to ensure FICA adherence and reducing fraud. Moving on to RefCheck. So RefCheck is a verification tool that you can use for screening of your tenants, specifically focusing on your credit reports, ID verification, criminal verification checks, and also employment history. See if the person is indeed employed. Also, what you need to know from RefCheck is that it's a consent-driven application. So before you can do a check on RefCheck, a consent form needs to be signed. And we do have an electronic consent option available. It is free of charge, and you can then send the electronic consent through to the tenant, and they will then sign it. It will link up automatically with all of the checks once you start processing everything. This is what a character reference looks like for the sample report. As you can see, the ID verification is over there, and this ID number, sorry, I had to blank out the ID numbers, but the ID number is true. Issue date on the card as well, and there we can confirm that the individual is alive. The ID number provided is verified, and it was issued to the surname and to the name. Very important using this check. When you submit this check, it won't only ask you for the ID number, it will ask you for the names as per the ID number, and then it will do the verification from there. As you can see, there's the employment history there, and we can confirm if an individual is currently employed. Moving on to Lexis Windeed, very powerful tool that you can use in the real estate world. We offer the TransUnion consumer profile, Experian consumer profile, the CompuScan consumer profile, and XDS consumer profile as a service whereby you can verify an individual's credit status. Yes, it does leave a footprint, and also with a TPN, where it will provide you with payment history of the specific individual. This is the sample report of your tenant profile network, and as you can see, it gives you payment information, positive information or default information, telephone and address information, and also it leaves a footprint on the individual's record. This is what your TransUnion consumer profile will look like, guys. This is a very important search that you can do when screening a possible tenant for in your rental side of the business. And as you can see, it provides us with consumer debt counseling information. If the person is under debt counseling, subject identification, meaning is the individual who they say they are they married, divorced? It will provide you with an ID number and also the dependents. Aliases, the addresses previously occupied, and also the consumer telephone history, and also employment history on file, which can also help you, like the employment, like the character reference and employment on RefCheck as well. Judgments, defaults on file, and also notices on file. Lastly, if we look at RefCheck, KYC, and Wendy, everything falls into this. We offer transactional billing, meaning you only get invoiced for the checks that you run. We have a badge feature available, which is actually very exciting for us because you can do a mass import on all your tenants to see if they are still, if they are able to afford the rent. No installation or registration fees. We offer free online training, free online support as well, where it's a web-based application, so you can access it from anywhere. And lastly, we have the live chat support functionality. So thank you everybody for joining, and please use the poll that will come up to indicate if you'd like to be contacted about registering for our verification solutions. Thank you and enjoy your day.
Thank you so much, Alan. There's the poll again. So if you like assistance or with any one of our products that Alan just mentioned, please just complete the poll. And I think we've got, thank you, Alan, so much. I think we've got one more question, or time for one more question. And I've heard this question many a times in the market, Adrian. So I'm going to read this one to you. And I think there's a lot of people that would also like to know this answer. Why must the bond originator and the property practitioner and the conveyancing attorney all do FIC or the FICA or get the FICA documents? Can the FIC compliance for each client be shared between the service providers?
Okay, so to answer that question, yes. The bond originators, all parties involved, the conveyancers, everybody needs to do their own due diligence for the simple reason that the FIC has made it abundantly clear that you cannot place reliance on the adequacy of the CDD done on clients on someone else's CDD processes or the CDD they've done. That is the simple, there's no special source or recipe, that's the answer. So you can place partial, I just want to be clear, you can place partial reliance. So like, I mean, if they, for example, the FIC asks us to do two things when it comes to customer due diligence processes: establish and verify, right? So let's say in part one, establishing the identity of a client. That entails finding out what is their name and surname. You could be provided with, let's say you place some reliance on that component, the establishing of the individual's name, but now aspects pertaining to verifying the veracity, the adequacy of that information, that onus rests solely on you. So there can be long and short partial reliance on CDD done by other stakeholders, everybody's working together, if there's a logical connection between everybody. But the long and the short is you cannot outsource your CDD obligations and you cannot place reliance on other people to fulfill your CDD obligations.
Thank you, Adrian. And just touching on that as well, there was a question relating to this asking, so let's say you have used Lexis KYC and you've got the report. Do you think it's wise, or may you share that KYC report with the client, for instance? And let's say, for instance, you did pick up something, there was something on world compliance or something. What is your thoughts on, may you share that with the client?
I think the guiding provision here, and I am so sorry to anybody listening, I can't recall the exact section of the FIC Act, but we live in the modern world, get the PDF version, open the FIC Act. There's a section that addresses tipping off specifically. It deals with this matter, and I would say a fair amount of depth. I think there's certain things that you can share with clients in that regard, But for example, if you've detected something on WorldCheck that potentially gives rise to the need to submit a suspicious activity report, this is where the tipping off provision in the FIC Act kicks in. If you suspect that that is going to tip the client off, scare the client off, and hinder you from assisting the FIC and submitting the report and so on and so forth, then it'd be ill-advised to inform the client of such. That would be tipping off. You cannot do that. Okay, so there are instances where you can, but I would say refer to the legislation where it specifically deals with the matter of tipping off. Okay, I hope that sufficiently answers the question.
Thank you, Adrian. We are on 3 o'clock on the dot, so we've had a full afternoon. There's a lot of information that you've got. I hope you enjoyed it. I hope that I certainly am a lot more richer with all the information that you gave to us, Adrian. So thank you for joining us, and we look forward to making contact with you and to our next webinar where we will unpack this even more. Have a lovely afternoon.
Absolutely.
And thank you, everybody.
Thank you very much.
Bye.
Thank you very much.